What would make elite attorneys, the kind who charge more per hour than most people make in a week, walk away from one of the most high-profile clients on earth all at once, because that's exactly what just happened. Within days, key members of Donald Trump's legal defense team stepped aside right as his cases are racing toward trial, not junior lawyers, not background staff. We're talking about the people who helped build the core strategy meant to shield him from criminal exposure, and their exit didn't come after a quiet disagreement or a routine shuffle. It followed a major courtroom setback that tore through the foundation of his defense like a wrecking ball. Suddenly, the lawyers closest to the fight are calculating risk, not political risk, personal risk, career risk, the kind that makes seasoned professionals ask a question they almost never ask mid-case: is staying on this worth it? Because when the people who know the case best start backing away, it means something behind the scenes has shifted hard. And the ruling that triggered this didn't just hurt, it changed the rules of the game. But that's only the surface of what's unfolding. The turning point came from the one place Trump's legal team had been counting on to buy time: the Supreme Court. For months, his defense strategy leaned heavily on one idea: that actions tied to the presidency could be shielded from criminal prosecution. If that argument held, entire cases could stall, shrink, or even collapse before reaching a jury. It wasn't just a legal angle. It was the foundation everything else was built on. Then the High Court stepped in a decision that sent shockwaves through legal circles. The justices made clear that the path Trump's team was trying to take just got dramatically narrower. The ruling didn't end his cases overnight, but it stripped away the broad protective wall his lawyers had been trying to build. Suddenly, arguments that once bought delays started looking like dead ends. What most people didn't see was the scramble that happened behind the scenes just hours after that decision dropped. Phones started lighting up. Senior attorneys who had spent months shaping motions and courtroom strategy were suddenly forced into damage control mode. Because this wasn't just about losing an argument. It was about what continuing to push certain defenses might now signal to judges watching closely. In high-level litigation, there's an unspoken line: you fight hard, you challenge, you test boundaries, but once a higher court draws a bright marker, stepping over it can start looking less like advocacy and more like defiance. That's where professional risk creeps in: sanctions, credibility damage, reputational fallout that follows lawyers long after one case ends. So what most people didn't see was the scramble that happened behind the scenes just hours after that decision dropped. Phones started lighting up. Senior attorneys who had spent months shaping motions and courtroom strategy were suddenly forced into damage control mode. Because this wasn't just about losing an argument. It was about what continuing to push certain defenses might now signal to judges watching closely. In high-level litigation, there's an unspoken line: you fight hard, you challenge, you test boundaries, but once a higher court draws a bright marker, stepping over it can start looking less like advocacy and more like defiance. That's where professional risk creeps in: sanctions, credibility damage, reputational fallout that follows lawyers long after one case ends. So the converse much colder. What exposure are we taking on personally if we stay the course? And for attorneys whose entire careers depend on the trust of judges, firms, and future clients, that question hits differently. Especially when the cases ahead aren't small hearings, they're complex federal trials with national attention and zero margin for error. That's when staying on the team stopped feeling like a legal strategy and started feeling like a gamble. And once that mindset took hold, the exits began. The first sign that something bigger was happening didn't come from a press conference or a headline. It came from paperwork: dry, technical, easy to miss unless you know what it means. Withdrawal notices started appearing on federal court dockets. One name at first, then another. Then more, not assistants, not temporary consultants. Senior attorneys tied directly to core parts of the defense strategy were formally stepping away from active cases. In legal language, it sounded calm and procedural. In reality, it was a siren, because lawyers don't leave high-profile federal cases in the middle of the storm unless something has fundamentally changed. These cases were heading toward trial phases where preparation is everything: witness strategy, motion battles, jury selection planning. Walking away at that stage inside the legal world. Moves like this send a message without anyone saying it out loud. The risk calculation shifted. And when multiple attorneys reach that conclusion within days of each other, it stops looking personal and starts looking structural. Now the courts had a new problem on their hands. Not political, not theoretical, practical. Who's actually steering the ship now? And that question was about to land directly in front of a federal judge. When those withdrawal filings reached the judges, the tone changed instantly. Federal courts don't like surprises, and they really don't like last-minute instability in complex criminal cases. Trial calendars are tight, juries are scheduled, and prosecutors are already deep into preparation. So when key defense attorneys start stepping aside, judges don't see drama. They see potential delays, appeals, and procedural chaos. At one hearing soon after, the question hanging in the air wasn't subtle. Is the defense actually ready to go to trial? Because if the answer is no, the court has options. Judges can refuse to slow things down. They can demand remaining counsel step up. In extreme situations, they can even bring in standby or court-appointed attorneys to make sure proceedings stay on track. And that's not attorney turnover doesn't automatically equal delay. That changed the pressure completely. Now, this wasn't just about legal theory or strategy debates behind closed doors. The timeline was real. The court's patience was limited, and whoever stayed on the team would have to walk into one of the most high-profile trial environments in the country with little room to maneuver, which raises the next problem no one on the outside thinks about. Who would even want to step into that position now? Would an even Vemmel of no one on the outside thinks about who would even want to step into that position now? That question, who would step in now, is where things get uncomfortable. Because taking over a normal federal criminal case is one thing. Taking over multiple nationally watched cases midstream after major legal setbacks under nonstop media scrutiny, that's a different level entirely. Any new attorney wouldn't just be inheriting files, they'd be inheriting months of rulings, established court expectations, and a defense strategy that just took a serious hit. And in the legal profession, reputation isn't just ego, it's currency. Lawyers build careers on credibility with judges, firms, and future clients. Stepping into a case where every motion is dissected, every argument is second-guessed, and every loss is public can feel less like an opportunity and more like walking into a spotlight you can't control. There's also a practical side people overlook. Federal trials at this level involve mountains of discovery, expert witnesses, procedural traps, and non-stop deadlines. Normally, teams prepare for years. Anyone joining late would have weeks, maybe less, to get up to speed in cases that could define their careers. So the hesitation isn't mysterious. It's math. High workload, high visibility, high risk, and uncertain payoff. That's why legal analysts started saying this situation isn't just a defense problem. It's a recruitment problem. And if that pool of willing, experienced attorneys keeps shrinking, the next phase of this story doesn't just get complicated, it gets historic. What makes this moment different is that legal team shakeups